Good morning, dear students. Once again, I would like to welcome all of you to a new session of the Civics class. Today, we are continuing with the same chapter from Civics, chapter number 4, the Supreme Court, part 2. Do you remember what we were discussing in the previous class? In the previous class, we were discussing three main points. First of all, we were discussing about the different specialities of our judiciary. And secondly, we were discussing about one of the specialities of our judiciary, that is single integrated system. And we have seen what is meant by single integrated system. And finally, we were discussing about the need for a single independent judiciary. So these were the three different points which we were discussing in the last class. And today we are going to discuss something further, something which is the continuation of the last class. First of all, we will be discussing about qualifications, the different qualifications to become a judge in the Supreme Court. Second one, how the appointment of a judge takes place in the Supreme Court. And finally, appointment of ad hoc judges. Ad hoc means when necessary or needed. That's what is the meaning of the word ad hoc. So, whenever it is necessary, whenever it is needed, certain judges can be appointed. So, how it is being taken place? So, these are three different points which we are going to discuss in today's class. So, without wasting time, let's move to the class. Qualifications. A person is not qualified for appointment as a judge of the Supreme Court unless he is not the citizen of India. So, if a person has to be appointed as a judge, the first qualification is, what is that? He must be a citizen of India. So if that person is not the citizen of India, there itself it is clear that he cannot become a judge in the Supreme Court. So that person must be a citizen of India. If that person is the citizen of India, then the following qualifications are required. First one, he has been for at least 5 years a judge of a high court or of 2 or more such courts in succession. That person must have rendered his service as a judge of a high court for at least 5 years. In other words, at least for 5 years he must work as a judge of a high court or 2 or more such courts in succession. Okay. Second qualification says that he has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession. First point says that at least for 5 years he must work as a judge of a high court. Second point says that he must work as an advocate at least for 10 years of a high court. And the third qualification says that finally he is, in the opinion of the president, a distinguished jurist. He must have a good personality, he must have a good career, and throughout his profession he was having a very special quality in protecting the rights and other requirements of the people who approached the court for getting their justice. That's what is meant by distinguished jurist. He must have a quality to stand for the justice. So if a person is having all these 4 different qualities, he can be appointed as a judge in the Supreme Court. Now, how the appointment of different judges of Supreme Court takes place. Every judge in the Supreme Court is appointed by the president. So, first of all, keep in your mind, every judges of the Supreme Court is appointed by the president, in consultation with the judges of Supreme Court and High Court, besides the Council of Ministers. First of all, the president will be consulting with the Council of Ministers. Not only just the Council of Ministers, but the judges of Supreme Court and the judges of High Court. The president will discuss with all these people, and then and there only he can appoint a person as the judge of the Supreme Court. In the case of the appointment of a judge, of course, the president has to consult with the Chief Justice of India. Okay, without consulting the Chief Justice of India, the president cannot appoint a person as a judge of the Supreme Court. Consultation means concurrence, which means he has to ensure that the Chief Justice of India is agreeing with the decision of the president. That's what is actually meant by consultation. It doesn't mean that his decision will become the final decision of the president, but make sure that the opinion of the president and the opinion of the Chief Justice is same. Okay. In case of the Chief Justice, so we have seen the different judges are being appointed by the president with the consultation of the judges of Supreme Court and of High Court, besides the Council of Ministers. Even the Chief Justice can also express his concern regarding the particular judge. But in the case of Chief Justice, whom the president can consult? Usually the senior most judge of the Supreme Court is being appointed as the Chief Justice. Now, if Chief Justice is unable to perform the duties, there the president may appoint another judge of the Supreme Court as the acting Chief Justice. Suppose maybe because of the age, maybe because of some disease or some illness, physically that person is not feeling comfortable to perform his duties. In such cases, the president may appoint another judge of the Supreme Court as the acting Chief Justice. He will not be appointed as the Chief Justice, but that person will be appointed as acting Chief Justice. Now we are going to see the third point of today's class, that is appointment of ad hoc judges. What is meant by ad hoc judges? I have already told you about ad hoc judges. Ad hoc judges means a person who is being appointed as a judge for some special works. We will see how it happens. The Chief Justice may appoint an ad hoc judge for a period as may be necessary. So, whenever there is an issue or there is a problem, the power given to the Chief Justice to appoint a judge as an ad hoc judge for a period as the situation required. He got the power to appoint a person as ad hoc judge. Doesn't mean that he can act according to his wish and will, but he has to consult with the president, or in other words, with the consent of the president only he can appoint a judge as an ad hoc judge. And again, not only just with the president, he has to consult the Chief Justice of the High Court concerned. Suppose the Chief Justice of Supreme Court wants to appoint a person as an ad hoc judge in the High Court of Delhi. So, to whom he has to consult? First of all, he has to consult with the president. Then he has to consult with the Chief Justice of Delhi High Court. So, these two people has to agree with the decision of the Chief Justice of the Supreme Court. Then and there only he can appoint a judge as an ad hoc judge for a period of time as the situation requests. The Chief Justice, with the consent of the President, can request a retired judges of Supreme Court or High Courts to act as judge of the Supreme Court. So all these are according to the situation, and that's why I have already told you the appointment of ad hoc judges. Ad hoc judge means according to the necessity, according to the need of the situation, certain appointments of the judges are being taken place, and those judges are being known as ad hoc judges. They will not be having a very long years of service in the High Court or in the Supreme Court as a judge, but they will be appointed for a particular task. Once their work is over, they can go back to their previous post. So these are the different factors or the different information related to the qualification for appointment as judge of Supreme Court, then appointment of different judges and appointment of ad hoc judges. So dear students, I think these points are very clear to you. So in the next class, we will be discussing the remaining points related to the different factors and different elements related to the Supreme Court. And with this, I would like to wind up today's class. Thank you.